Legal scholars form an audience that scrutinizes every word of Supreme Court opinions. In distinguishing the scrutiny the High Court receives from journalists versus legal scholars, I noted, scholars have two key advantages over journalists and editorialists who report on court cases: space and time. Books and scholarly journals provide space for arguments to be elaborated, evidence to be adduced, and sources to be enumerated. And unlike journalists and editorialists, who normally face deadlines, scholars typically have considerable leisure to ponder, research, write, and revise their analyses. They also benefit from a better educated audience, especially those knowledgeable in the law. Legal scholars' interest in Supreme Court decisions is not merely intellectual. Most legal scholars are engaged in teaching in law schools, so they must scrutinize decisions to help their students come to an understanding of what the law is. There are almost 200 American Bar Association accredited law schools, which employ over 17,000 law professors. They, and in some cases their students, publish in almost 1,000 law journals. Thousands of books in law are published each year. The U.S. Supreme Court and its decisions are a popular topic of legal scholarship, given the impact their rulings have on the legal system. It is hard to imagine a comparably sized academic community that scrutinizes the ongoing writings of such a small group of writers so assiduously. Of course, the justices of the Supreme Court are well aware of the scrutiny of the legal academy. They cite scholarly articles in their own opinions where supportive. They regularly give lectures at law schools. From their own law school days, they understand that their opinions may be included in casebooks. Indeed, Ella Govstein notes of Justice Scalia, unable to persuade his colleagues, Scalia has confessed that he writes with verve and panache to ensure that his opinions are quoted by the editors of legal textbooks, so they can influence future generations of lawyers and scholars. While legal scholars may constitute a secondary audience at best, one can imagine that the Supreme Court justices would want to avoid being called out for making weak arguments, building on questionable assumptions or inconsistently applying legal philosophies to which they profess their allegiance. The legal community is about as close to Perelman and Ulbrecht Titica's ideal universal audience as one might hope to find.